If you or someone you love is an immigrant in the United States right now, you need to understand what is happening at a scale that has never been seen before in American history. ICE arrests have more than quadrupled compared to the final months of the Biden administration. Street arrests, meaning agents going into neighborhoods, workplaces, and communities, went up by a factor of 11. That is not a typo. 11 times. Deportations from inside the United States are now running at over 1,000 people per day. ICE has officially set a target of 1 million deportations per year. This series is going to break down exactly who is being targeted, what the data shows, what your rights are, and what you need to do right now to protect yourself and your family. Stay with me. This information could change everything. Here is the fact that surprises people the most, and it comes directly from official ICE data. The administration has repeatedly claimed it is targeting the, quote, worst of the worst. But the numbers tell a very different story. More than 1 out of every 3 people deported from detention in 2025 had no criminal record whatsoever. No pending charges, no prior convictions. Nothing. And it gets more striking. For every single at-large arrest of someone classified as a serious criminal threat, there were 12 arrests of people with no criminal record at all. Arrests of people without criminal convictions increased by 2,450%. That's not a rounding error. That is an entirely new enforcement reality. If you are undocumented and have never committed a crime, you are not safe from enforcement. That is the reality in 2026. Let's start with the group at the highest risk, undocumented immigrants who entered the country without inspection, meaning those who crossed the border without going through an official port of entry. In July 2025, ICE issued guidance stating that anyone who entered without inspection is ineligible for bond, regardless of how long they have lived in the United States, regardless of family ties, regardless of work history, regardless of community contributions. This means if ICE arrests you, you will almost certainly be detained while your case is processed. And the detention system is specifically designed to pressure people into giving up their cases and accepting deportation voluntarily. If you or a family member entered without inspection, even years ago, the risk of detention and deportation in 2026 is very real. The first step is to speak with an immigration attorney immediately to understand your specific situation and options. If you have a final order of removal already issued by an immigration court, meaning a judge has already ordered you deported and you remained in the United States, you are in one of the highest risk categories in 2026. ICE enforcement has historically prioritized people in this situation, and that has not changed. In fact, enforcement against this group has intensified significantly. ICE now has far more detention space, far more agents, and far fewer internal restrictions on when and where arrests can happen. If you have a final order of removal and have been living quietly in the United States, hoping it wouldn't catch up to you, that calculation has changed dramatically. The urgency to consult an immigration attorney has never been greater. There may be options, motions to reopen your case, applications for relief, legal protections you are not aware of. But time matters. Act now, not later. This one is critical, and it has shocked the immigrant community across the country. For years, immigrants on supervision were required to check in regularly with ICE. This was considered a safe legal obligation, something you did to show good faith and compliance. In 2025 and 2026, that changed completely. ICE began arresting people during their own scheduled check-ins. People who showed up voluntarily, as required by law, were detained on the spot and placed into deportation proceedings. Immigration court hearings have also become sites of enforcement. People who showed up to their own court dates, doing exactly what they were supposed to do, have been arrested in or near courthouses. If you have an upcoming check-in or court date, speak to an immigration attorney before you go. Understand your current risk level. Do not go without legal guidance in the current enforcement climate. Are you someone who came to the United States legally on a tourist visa, student visa, or work visa, and then stayed after it expired? This group is increasingly in ICE's crosshairs in 2026. Visa overstays have always technically been a civil immigration violation, but for years, interior enforcement rarely focused on this population. That has shifted. With expanded enforcement authority, more interagency data sharing, and cooperation between federal agencies, identifying visa overstays has become significantly easier. Airlines share travel data. Employers share records. The government now has more tools than ever to locate people who stayed beyond their authorized period. If you overstayed a visa, even by a short period, you should consult an immigration attorney to understand your current exposure. In some cases, there are still legal pathways available. In others, the risk of enforcement is immediate. Know where you stand. If you are a DACA recipient, a dreamer, your situation in 2026 is uncertain and, for some, actively dangerous. Courts have continued to battle over the legality of the DACA program. New applications have been blocked. The program's future is genuinely unresolved. And while current DACA holders have generally not been targeted for deportation based solely on their DACA status, the protection is fragile. The data shows that DACA recipients who have been arrested on any criminal charge, even minor offenses, have been transferred to ICE custody and detained, with deportation proceedings initiated. Additionally, anyone whose DACA status has lapsed due to missed renewals is in a significantly more vulnerable position. If you are a DACA recipient, keep your renewal absolutely current. Consult an immigration attorney about any changes to your situation, and understand that the protection, while still in place for now, is not permanent. Plan accordingly. Here's a misconception that puts legal permanent residents at serious risk: the belief that a green card makes you completely safe from deportation. It does not. Green card holders can be placed in removal proceedings and deported for several reasons in 2026. These include being convicted of an aggravated felony, drug offenses, domestic violence offenses, or crimes involving moral turpitude. They also include issues with the original admission, fraud or misrepresentation when first obtaining the green card. In the current enforcement climate, even minor criminal convictions are being scrutinized more aggressively than in previous years. Something that seemed resolved years ago may now be reopened. If you are a green card holder and you have any prior criminal conviction, even one that seemed minor or was expunged, consult an immigration attorney. Do not assume your status protects you from all risk. It does not. Know your specific exposure. If you work in an industry that historically employs large numbers of undocumented workers, agriculture, construction, meatpacking, cleaning services, food processing, pay very close attention. Worksite enforcement, which had declined significantly under previous administrations, has returned in a major way in 2025 and 2026. ICE is coordinating large-scale operations targeting specific industries and specific employers. During a worksite raid, ICE agents may question all workers present, not just those on a specific list. Collateral arrests, meaning people who were nearby a specific target and got swept up, are happening regularly. Knowing your rights in a worksite encounter is critical. You have the right to remain silent. You are not required to answer questions about your immigration status or place of birth. You have the right to speak to an attorney before answering questions. These rights exist regardless of your immigration status. Know them. Exercise them calmly. One of the most significant enforcement tools expanding across the country in 2026 is something called the 287G program. And if you've never heard of it, you need to understand it right now. Under this program, local and state law enforcement agencies partner with ICE. When someone is booked into a local jail, even for a minor offense like a traffic violation, their immigration status can be checked. If they are undocumented, ICE can issue a detainer, meaning a request to hold that person until ICE comes to pick them up. In Florida alone, the share of immigration arrests coming through this program jumped from 13% to 29% in just over a year. This means a routine traffic stop, a minor misdemeanor, or any encounter with local police can now trigger immigration detention. This is not limited to serious crimes. It applies to any arrest, in any state with a 287G agreement with ICE. Many immigrants have relied on so-called sanctuary city policies, local government decisions to limit cooperation between local police and ICE. But in 2026, the protection those policies offer has significantly weakened. The federal government has used multiple tools to pressure sanctuary jurisdictions, including withholding federal funding, filing lawsuits, and sending additional federal agents directly into those cities to conduct independent enforcement operations. The Los Angeles raids of mid-2025 were a direct demonstration of this approach. Hundreds of federal agents operating in a major sanctuary city, conducting neighborhood-level enforcement regardless of local policy. Living in a sanctuary city reduces some risk. Local police are less likely to cooperate with ICE, but it does not eliminate it. Federal agents can and do operate independently of local law enforcement. Do not assume a sanctuary city policy makes you unreachable. Federal enforcement operates under federal authority, and that authority has expanded dramatically. If ICE arrests you in 2026, what happens next is dramatically different from what it was just 2 years ago, and understanding this matters enormously. ICE detention has expanded by more than 75% in a single year, reaching a record of over 73,000 people held in custody. Congress has approved $45 billion in new detention funding, enough to build a system potentially 3 times larger than it is today. Here is the critical change. Release on bond while fighting your case in court, once relatively common for people without criminal records, has been essentially eliminated. By late 2025, discretionary releases from detention dropped by 87%. This means if you are arrested, you will almost certainly remain in detention for months while your case proceeds. This reality is deliberately designed to pressure people into accepting voluntary deportation rather than fighting their cases. An attorney, reached before or immediately after arrest, is your most important resource. One of the most heartbreaking aspects of the current enforcement climate is what is happening to mixed-status families, households where some members are U.S. citizens and others are not. Having U.S. citizen children does not protect an undocumented parent from deportation. It is a factor that may be considered in immigration court proceedings, but it does not automatically halt removal. Families are being separated. Parents are being deported while their U.S. citizen children, who have every legal right to remain, are left behind, sometimes in the care of other relatives, sometimes entering the foster system. If you are the undocumented parent of a U.S. citizen child, there are legal steps you can take now to protect your family's future, including designating a legal guardian for your children in the event of your detention. Do this now, not when ICE is at your door. Preparation when nothing is happening is the only preparation that actually works. If you came to the United States seeking asylum, fleeing persecution, violence, or danger in your home country, your pathway in 2026 has become significantly more difficult and uncertain. The administration has used executive authority to restrict asylum at the border and to expedite removal proceedings for those who cannot immediately demonstrate a credible fear of persecution. Courts have been actively litigating these restrictions, with some judges blocking specific policies. But the legal landscape is shifting constantly, and the window for asylum claims is narrowing. Those with pending asylum cases who have been in the country for months or years are not immune from enforcement. Cases that were moving slowly through the courts are now being fast-tracked in some jurisdictions. If you have a pending asylum claim, the absolute priority is maintaining legal representation. An attorney who knows your case and can respond quickly to changes is not optional. It is essential for your protection. The current enforcement environment has also created heightened risk for immigrants from specific countries, particularly those from nations with which the United States has strained diplomatic relationships or expedited removal agreements. Deportation flights to countries including Venezuela, Cuba, Haiti, Guatemala, El Salvador, Honduras, and others have been operating at historic frequency. Agreements with some countries that previously refused to accept deportation flights have been renegotiated under significant diplomatic pressure. Chinese nationals have also appeared in increasing numbers in recent deportation reporting. as have nationals from several African and South Asian countries. The country you are from affects not just whether you can be deported, but how quickly and through which legal process. Some nationalities face expedited removal with fewer procedural protections. An immigration attorney who specializes in country-specific cases for your nationality can assess your individual risk and identify protections that may apply specifically to you. If you are ever stopped by ICE agents, whether at your door, on the street, at work, or anywhere else, the next 60 seconds matter more than almost anything. Here is what the law says you have the right to do, regardless of your immigration status. You have the right to remain silent. You do not have to answer questions about where you were born, how you entered the country, or your immigration status. You have the right to refuse to sign any documents without first speaking to an attorney. If ICE comes to your home, you do not have to open the door unless they present a judicial warrant, signed by a judge, not just an administrative ICE warrant. You have the right to speak to an attorney. Ask for one immediately and clearly. These rights are guaranteed. Exercise them calmly, without resistance, but firmly. Do not run. Do not argue. Know your rights and use them. One of the less discussed but critically important dynamics of 2026 immigration enforcement is what's being called the voluntary departure strategy. And it is something every immigrant needs to understand before they are in a position where they feel pressure to sign anything. Because detention conditions have become so difficult, and because release on bond is now almost impossible, many detained immigrants are choosing to give up their legal cases and accept voluntary deportation, just to get out of detention faster. Voluntary departures increased by 28 times compared to previous years. This is not coincidence. It is the intended result of a system designed to make fighting your case from inside detention as difficult as possible. Here is the problem. Signing a voluntary departure agreement may permanently bar you from certain forms of relief and from returning to the United States. Do not sign anything without speaking to an attorney first. Even inside detention, you have the right to legal counsel. Exercising that right could change your entire future. The enforcement wave of 2025 and 2026 has not left children untouched, and parents need to understand what is happening and what protections still exist. Unaccompanied minors, children who cross the border without a parent or legal guardian, have historically had additional legal protections and specific due process rights. Those protections have been challenged and, in some cases, reduced under the current administration. Children who are in the United States with undocumented parents face the traumatic reality of potential family separation if a parent is detained or deported. Organizations including ACLU, RACES, and local legal aid societies are actively working to protect children's rights in this environment. If you are a parent, documented or not, you should create an emergency plan for your children now. Designate a trusted adult who can care for them legally. Ensure your children know key phone numbers. Keep important documents in a safe, accessible location. Preparation is protection. Immigration enforcement in 2026 is not happening equally across the country. Geography matters, and knowing where enforcement is most concentrated can affect the decisions you make. Texas leads all states in total ICE arrests by a significant margin. Florida has dramatically expanded enforcement through its 287G program, now arresting more people than California, despite having a smaller, undocumented population. States with strong local law enforcement cooperation with ICE, including Florida, Texas, Georgia, and Arizona, see far higher rates of immigration arrests than states with sanctuary policies. However, as the Los Angeles raids demonstrated, even in states with sanctuary policies, federal agents operate independently. California, New York, and Illinois have all seen significant federal enforcement operations despite local resistance. The difference is meaningful, but not absolute. Where you live affects your risk level, but it does not eliminate it. Federal authority operates everywhere. Local policy is a partial buffer, not a guarantee. We've covered the full picture. Now let me leave you with the most important message of this entire series. What you need to do right now, today, not tomorrow. First, Speak to an immigration attorney. Not a notario, not a friend who knows someone. A licensed immigration attorney who can assess your specific situation and give you real legal advice. Second, organize your documents. Gather passports, visas, any immigration paperwork, birth certificates, and any evidence of your time in the country. Keep them in one safe, accessible place. Third, make a family emergency plan. Know who takes care of your children if you are detained. Know which phone numbers your family should call. Know your rights. Fourth, do not ignore any legal notices or court dates. Ignoring them makes your situation significantly worse. Fifth, stay informed from reliable sources. Immigration law is changing fast. What was true 6 months ago may not be true today. Information is power. Use it.